Welcome to the Jackson Kelly webinar, MSHA's proposed rule on penalties, what does the future hold? Before we start, I'd like to take a moment to address some administrative issues. Because we want to make sure we limit this presentation to no more than 60 minutes, questions will be answered at the end of the presentation. For those of you participating from your computer, questions may be submitted using the Q&A pane located at the bottom right of your screen. If you have technical questions during the course of the webinar, you may use the Q&A pane or send an email to marketing@jacksonkelly.com. The full presentation will be sent to you via web link. Included in this email will be a link to a voluntary survey. We will use your responses to the survey to plan future webinars and events. All participants' phones have been muted at this time, and the presentation is now being recorded. Thank you all for attending. Today's webinar is presented by Chris Peterson. Chris is a member in Jackson Kelly's Safety and Health Group. He advises clients in all aspects of workplace safety in the mining industries here in Colorado and across the country. Chris specializes in crisis management, coordinating serious injury and fatal accident investigations on behalf of the employers. I will now turn it over to Chris Peterson.
Thank you, everybody, for calling in. And today we're going to be talking about MSHA's proposed rule on penalties. It was published in the Federal Register on July 31st, and I would like to point out that the comment period has been extended from September 29th to December 3rd. So at the conclusion of this, if it occurs to any of you to work on some comments, or you would like to comment, have questions on how to do that, I can direct you to the Federal Register documents that kind of gives you instructions on how to file some comments. So we can get started, and thanks again for taking time out of your busy Friday. I'm sure you all are emotionally preparing for the Super Bowl rematch between the Broncos and the Seahawks on Sunday. Personally, I'm hoping for a better result. I don't know if it could get much worse for the Broncos. But anyway, let's start talking about the proposed rule. Now, the proposed rule, I think has been in, well, I know it's been in the works for quite some time. And MSHA's intent is to modify the regular assessment penalty formula currently at 30 CFR Part 100. And I typically explain the regular assessment formula like this. If you look at a typical citation or order form, I'm sure most of you have seen those, right, where we have various boxes that an inspector checks, or at least designations typed into a computer that are then therefore check the boxes. And those boxes essentially correspond to numbers, points, if you will. And at the end of the day, those points are all added up, and that point total corresponds to a dollar amount. So in a nutshell, that is the regular assessment formula. So MSHA is proposing to change some of that, and we'll go through the changes, essentially looking at some modifications or reductions in the various subcategories of gravity, for example, negligence. Those are the most significant changes. And then basically reformulating the penalty table in Part 100, 30 CFR Part 100, to correspond to a revamped penalty system in which the overall penalty points are reduced and yet correspond to greater dollar amounts. And that might be confusing, but we'll get into some examples towards the end as far as basically how all this is going to shake out. But in a nutshell, I expect penalties to increase. And I think it's probably worth mentioning that even though MSHA's intent is to change the regular penalty assessment formula, I think it will have some impact on special assessments. And again, special assessments are basically the black box of penalty assessments, right, where we don't have a lot of direction as how MSHA goes about assessing these special assessments, but MSHA can essentially pick a penalty amount to more properly assess a penalty for a particular violation when MSHA believes the regular penalty assessment does not provide, in most cases, adequate deterrence to increase operator compliance. So those are some loaded words there, but we'll talk about that in a little bit. All right, another purpose of MSHA publishing this proposed rule and proposing to change the existing rule is to make it easier for inspectors to issue citations and orders in terms of making determinations on gravity and negligence and presumably, right, whether there was a violation to begin with. And this is all part of, I think, an overall strategy to reduce litigation. I can tell you probably several years ago now, I was on an accident investigation, and I was talking to a relatively senior Department of Labor solicitor, so one of these government attorneys that represents MSHA. And we were at the accident investigation, we were sort of in between interviews, and he turns to me and says, "Chris, what's going on with the industry? Why are they contesting all of these citations and orders?" And I looked at him and I was like, "Well, what do you mean, right? I mean, probably because they don't agree with the paper." He's like, "Well, it's the government's thought that this was an industry-wide conspiracy to contest as many citations and orders as possible in an effort to overrun the system and cause it to break down." And again, to put it in context, this was sort of at the peak of the backlog, the quote-unquote backlog, right, where, probably starting 2007, MSHA had modified the penalty regulations to basically increase penalties. We saw a significant penalty amount increases. We also saw significant enforcement increases in terms of MSHA issuing more citations and orders. As it turns out, right, many operators decided they didn't necessarily agree with what MSHA was issuing, and that was the basis for, and I guess the government was right, the basis for a higher contest rate. But I was at a loss to address the conspiracy theory where, right, I mean, working with various operations throughout the country, it just blew my mind to think, every coal mine in the United States, can hop on a conference call, for example, and say, "Okay, we're going to contest everything that's been issued to us. We're going to bring the system down." But I mention this, right, because I think a lot of the proposed changes in this rule are aimed at reducing issues that can be litigated. And I think the perfect example is when we start talking about negligence, and we'll see how the reduction in the negligence categories, can potentially reduce overall litigation. And one of the final points that we'll make today in terms of talking about the Mine Safety and Health Administration and their power struggle, if you will, with the Federal Mine Safety and Health Review Commission is the concept of penalty assessments and limiting the authority of the Federal Mine Safety and Health Review Commission to assess penalties and make changes in the litigation process. And so again, we'll sort of touch on this issue again, but I think it's an overarching theme, if you will, of this proposed rule. This kind of caught my eye. I don't know how close some of you may be following the pattern of violations litigation, but essentially, right, with this new pattern of violations rule, I believe it was published last year, the big change in the pattern of violations rule is pattern of violations, an order of pattern of violations can be based on citations and orders issued to an operator, right? These citations and orders do not have to become final in order for them to be used in the pattern of violations analysis, right? Who's eligible to go on patterns, and even putting an operator on patterns, right, doesn't require that the citations and orders used in that calculus be final orders. And what I mean by final orders is, for example, a citation is issued, or an order, right, is issued to an operator. That operator doesn't contest it. The operator pays the penalty. At that point, that citation or order becomes final. Even if an operator contests the citation or order, once that is either settled and the decision approving settlement is approved by a judge and they issue an order, that becomes final, typically within 30 days. Or if you go in front of a hearing in front of an administrative law judge, you receive a decision, right, and if you appeal it or not, but basically at the end of that process, that hearing process, then that citation or order, assuming it's not vacated, right, becomes what they call a final order. So MSHA has clarified in its proposed rule that an operator's violation history will be based on final orders and sort of a rolling 15-month period based on the issuance of a particular citation, right? So an operator's violation history comes into play for violations per inspection day, repeat violations of the same standard, for example, and can start accumulating these enforcement history points, which are a category in the regular penalty assessment formula. So how that essentially functions, and we'll take a look at an example at the end of the presentation. But essentially, right, the more repeat points you have, the more enforcement history you have in terms of points, obviously increases your assessed penalty. So that can be significant. But I just thought that was an interesting change from MSHA's position saying, oh, well, pattern of violations, it's okay to do issued, but for enforcement history itself, it's based on final orders. And so, one of the arguments that they make in the pattern of violations litigation is, we want to be able to capture, if you will, current mine enforcement, and yet, for the purposes of your enforcement history for penalties, they're willing to, deal with citations that have been settled or issued, well beyond the 15-month period, and then they'll hit your enforcement history at various times, either when those citations are paid or settled, or a decision from the judge comes out. So I thought that was an interesting change. And we'll talk about this particular issue when we're talking about our example. But it's important to understand, too, is your enforcement history is based on final orders in a 15-month period from the date of issuance of any particular citation. But the changes include a sort of a reweighting, if you will, a redistribution of these points. And so a greater weight will be placed on your history of violations. And so again, when we talk about an example, we'll talk about how that essentially works. But what I'm saying is, essentially, if you have a higher repeat point, right, that is going to increase your points more than it currently does. All right, so getting into some of the main issues here in this proposed rule. Is negligence. Negligence is, I think, a significant change. Where again, if you're thinking in terms of what negligence is today, we have, 5 categories, ranging from no negligence all the way up to reckless disregard. The proposed rule is proposing to reduce these categories from 5 to 3. Okay? So we maintain the no negligence, renaming it not negligent. We eliminate or combine, if you will, the low negligence, moderate negligence, and high negligence into one category simply called negligent. And we maintain the reckless disregard. And so remember when we first started today, when we're saying eliminate options, right? Reduce inspectors' confusion perhaps by simplifying the choices an inspector has to make. So now we're basically faced with an inspector deciding whether or not an operator was not negligent or negligent, or their negligence was up to reckless disregard. I think it's important, too, to point out not negligent, the definition of not negligent is the operator exercised diligence and could not have known of the violative condition or practice. Reckless disregard is defined as the operator displayed conduct which exhibits the absence of the slightest degree of care. And negligent, the definition of negligent, if I can get to, hold on. Technical difficulties. All right. My keyboard stopped working. But here we are. So negligent would be defined as the operator knew or should have known about the violative condition or practice. So between the two extremes of not negligent and reckless disregard, we have simply negligent. And so for those of you who are familiar with the concepts of negligence under the current rule, you'll know that low negligence, moderate negligence, and high negligence, a big part of the determination, well, what should be a part of the determination between those levels of negligence is considering what MSHA calls mitigating circumstances. So, for example, if an MSHA inspector issues a citation or order, right, with high negligence, basically, right, that's the determination that there are no quote-unquote mitigating circumstances. If an inspector issues a citation with moderate negligence, then there are quote-unquote mitigating circumstances present. Low negligence would be considerable mitigating circumstances. So you can see what MSHA is proposing to do here is certainly, right, simplifying the choices for the inspector, right, negligent versus not negligent, or, right, reckless disregard, but there is no, under this proposed definition, no consideration for mitigating circumstances. So in terms of, under the current rule, right, how many folks see citations issued with no negligence? I think those are fairly rare, not common at all. And so the concern is, right, MSHA is just going to check the box negligent, or, right, quite possibly lead to additional reckless disregard citations and orders being issued. And reckless disregard, as I'm sure most of you know, right, can trigger what are called flagrant assessments. And a flagrant assessment is essentially when an operator has failed to eliminate a known violation of a mandatory safety or health standard. And so, right, and they carry penalties up to $242,000. And those are assessed under the special assessment process. And so again, going back to one of the controlling themes here of this proposed rule, when MSHA is saying, you know, we want to make these changes so that there are fewer areas of disagreement, facilitating resolution of enforcement issues. So think about it, if you will, right? So you decide to conference a citation or contest a citation, right? And so it's been marked negligent. What are you going to argue, right? Oh, we were not negligent. And so I guess we'll see, right? I mean, maybe MSHA is going to change their entire concept of what negligence is, and so maybe, right? And maybe I'm being optimistic here, right? But maybe, right? Then the argument becomes we're not negligent. We exercised due diligence. We could not have known of this violative condition or practice, and maybe we get reductions to not negligent. Think about it in terms of as well, if you contest a citation and you take that citation in front of a judge, and what is the judge faced with? Is he faced with the prospect of either affirming operator negligence or saying that you weren't negligent? Now the definition, the proposed definition, doesn't include any sort of, like I said, considerations for mitigating circumstances. Now technically, I suppose the judge isn't constrained by any of MSHA's definitions in Part 100, so again, in theory, would not be constrained by this new definition for negligent. So again, right, the judge could very well continue to consider mitigating circumstances. But at the end of the day, where does that get us? Right? So what if a judge says, okay, well, you were low to moderate, operator had low to moderate negligence involved in this particular citation? Where does that put us in terms of a penalty assessment? So again, we'll talk a little bit about this in one of the final points today, this power struggle, right, between the Mine Safety and Health Administration and the Federal Mine Safety and Health Review Commission in terms of whose authority controls penalty assessments when you take these issues in front of a judge. And that's certainly something that's involved in that. And then, of course, right, our friendly and familiar citation and order form would be revised to reflect fewer categories, negligence categories. And, right, when we talked about the weighting of the penalty points, MSHA is proposing to increase the weight of the negligence. So your negligence will have a larger impact on your overall penalty points, okay? And so essentially, just to put it in terms of numbers, right, not negligent, for example, would be assessed 0 points. Negligent would be assigned 15 points, reckless disregard 30 points. And so in terms of your overall points total, your negligence is going to play a larger role in that. All right. I think another significant change is modifications or changes, if you will, in the gravity determination. Gravity is a fancy word to say S&S, significant and substantial. So the existing rule, right, provides these three factors: the likelihood of occurrence, the severity of injury or illness, number of persons affected. Right, those are the factors involved in the S&S analysis, if you will, or at least the first two, number of persons affected. We'll talk about that in a second. And so the proposed rule is keeping those same three gravity factors. So in theory, right, the S&S concept hasn't changed much in terms of what is involved in determining whether something is S&S, right? Under the current rule, remember, right, for something to be S&S, it has to at least be lost work days, restricted duty, and reasonably likely. So if you get a reduction from reasonably likely to unlikely, for example, right, it becomes non-S&S. And in the vast majority of cases, when an operator is arguing against S&S, they are arguing against that likelihood, right? Reducing that reasonably likely to unlikely, or highly likely to unlikely, for example. So essentially, the proposed rule is going to keep these gravity factors, but reduce the number of subcategories. So when we say subcategories of the gravity analysis under likelihood, current rule, right, ranges from no likelihood up to unlikely, then reasonably likely, then highly likely, then occurred. Okay, so those 5 categories, proposed reduction to 3 categories: unlikely, reasonably likely, and occurred. So essentially consolidates the unlikely and no likelihood into one category, unlikely. Eliminates the highly likely category, right? And so leaves us with those 3. And again, just in terms of points, and I don't want to get too complex. I want to stay sort of big picture here, right? But just in terms of points, you understand, unlikely would be assigned 0 points, reasonably likely would be assigned 14 points, and occurred would be assigned 25 points. Now, I think there's two significant issues with these subcategories under the proposed rule. Reasonably likely would have a different definition. So reasonably likely would be defined as condition or practice cited is likely to cause an event that could result in an injury or illness. Okay? Now, I find it interesting, right, when they say what's reasonably likely, and then they say condition or practice cited is likely. Well, I think likely is different than reasonably likely, right? And then cause an event that could, right, that word could, I think is a significant change. And could really opens up the definition to what is possible. Right? You guys see how that expands the definition of reasonably likely. I think this is a significant issue, that if this proposed rule were enacted with this definition intact, this is going to be interesting to see how this issue is litigated, right? To see how these judges treat this new definition. I can tell you, under current case law, the reasonable likelihood, right, is defined that the hazard contributed to will, and they use the word will, result in an injury. And so this proposed definition changes will to could. So you can see what I'm saying when I say it's a much more expansive definition. And then occurred. The subcategory occurred, I think, is significantly expanded. Currently, under the current rule, right, when an inspector checks the occurred box, means an actual accident or injury, right, has taken place. Or excuse me, an illness or injury has taken place. Right? So something has actually occurred. Not could occur, right, under this proposed definition, for example, condition or practice cited has caused an event that has resulted or could have resulted in an injury or illness. So that, I mean, that clearly takes, I think that definition clearly takes current practice of actual injury into a realm of conjecture, right? What could have happened? What could have resulted? And so again, right, I think in litigation after this, I mean, that's going to be a significant issue in determining, right, what is possible. I mean, think about it in terms of a rock fall or an accumulation citation, right, that would be even more expansive. You're cited for an accumulation of combustible materials, right? What could have resulted? Well, I guess what the mine could have burned down. And in terms of a rock fall, right? Oh, that could have injured a miner, could have killed somebody. And so I think, and again, you know, when I was talking just briefly about the points, and we'll see this in our example as we wind up today, but the difference between reasonably likely and occurred is 11 points. So keep that in mind. Okay. And then finally, the second part of this S&S analysis is severity of injury or illness. And so essentially what we're doing here, the proposed rule eliminates the permanently disabling category, leaving us with 3 subcategories for severity of injury or illness: no lost work days, lost work days or restricted duty, and fatal. And no lost work days would be assigned 0 points. Lost work days restricted duty would be assigned 5 points, and a fatal designation would be assigned 10 points. So no more permanently disabling, and the proposed definitions of these remaining severity categories would not change. And so I've referred a couple of times with this S&S analysis, lack of direction right from the proposed rule, and possible litigation over these new expanded definitions of reasonably likely and occurred. Keep in mind, right, the 4 Matthews criteria, which makes up the current S&S analysis, could very well change. In terms of challenging S&S, arguing against an S&S determination, you're typically arguing against the likelihood. And so under the Matthews criteria, and again, I mentioned this earlier, right? Under the Matthews criteria, there's a reasonable likelihood that the hazard contributed to will result in an injury. Now that word will is changed to could, so clearly more expansive. And then reasonable likelihood that the injury in question will be of a reasonably serious nature. I think that we'll see that factor probably be fairly consistent. I know a lot of inspectors out there are apt to check the fatal box. So, I don't know if that argument is going to change much, right, between fatal and lost work days, for example. But, I think it's important to point out, right, that there is no discussion. MSHA is not addressing potential changes in that S&S. Now look at this. Proposed rule reduces the number of persons affected categories to 2. No persons affected or 1 or more persons affected. And I thought, when I read this, I was thinking to myself, well, does this category, persons affected, right, does that become irrelevant? I mean, basically, we're looking at no persons affected assigned 0 points. 1 or more persons affected is assigned 1 point. So if we're talking 1 point, and honestly, I think that's probably a good development, simply because under the current rule, we have a range from, 0 to 11 persons or more affected, and the point totals are a range from 0 to 18 points. So I think that, or possibly 11 points. But anyway, point being, I think this proposal, if there's any positive aspect or positive change, this could be it. All right, well, there we go. Okay, I wanted to mention this a little bit because MSHA has come up with this in their proposal. Incentives for not challenging enforcement actions. And the thought occurs to me when I started reading about this, sort of, have we been conditioned to accept this? Many of you remember the good old days, right, when you challenge a citation, you get, or order, right, and you get some reduction of that citation or order, and that reduction is taken into account through the regular assessment process. So, for example, if you challenge an S&S citation and you get the likelihood reduced from reasonably likely to unlikely, the penalty points would be recalculated and the penalty would be assessed on that new recalculated penalty amount. I think it's fair to characterize that process as operators would realize in certain cases significant penalty savings. And again, I think as a byproduct of this quote-unquote backlog, right? Don't forget the industry conspiracy created backlog. As a byproduct of that, probably starting around 2008, 2009, we saw through the contest process a reluctance on certainly MSHA's part and the solicitor's office and the newly created quote-unquote backlog group that when a citation or order was reduced, they would give you sort of an off-the-top generic 20% penalty reduction. Or I think it even started when they first started doing that, like at 30%. And then it's sort of whittled down to 20%. And now it's sort of hit or miss, right? If you can get 20%, you're probably doing pretty good, right? So I think MSHA's conditioned operators to kind of think this is a good idea. And what I'm talking about is that the proposed rule basically maintains the 10% penalty reduction for good faith abatement, okay? And that stays the same. But basically, MSHA is proposing to redefine what they call good faith, right? To include not only abatement, but also payment of the proposed penalties. So what MSHA is saying here is that if the operator does not contest the citation or order, you can expect to receive up to a 30% penalty reduction. And so again, right, in terms of the contest process as we know it today, you know, oftentimes we're arguing over S&S. Operators are concerned about eligibility for pattern of violations. They're concerned about elevated enforcement actions. They're concerned about unwarrantable failures. So we're getting these reductions on the paper, but again, we're seeing sort of blanket percentage reductions, 20% reductions in the penalties. So what MSHA has been encouraging the solicitor's office and the conference litigation representatives to do, and these backlog attorneys, right, they want to take away the operators who are thinking in terms of penalty savings and trying to reduce the number of contests through that. All right. So a few minutes ago, we were talking about the concepts of negligence. And MSHA talks about unwarrantable failures in terms of increasing statutory minimum penalties for 104 D1 citations and orders and 104 D2 orders, again, in the proposed rule. But there is no mention in that discussion of negligence or 104 D1 citations and orders or D2 orders and their penalties. There's no discussion about the unwarrantable failure case law analysis. And I think that's a significant issue in terms of the current definition, or case law definition, if you will, right, of an unwarrantable failure, aggravated conduct constituting more than ordinary negligence. So in terms of, right, so if MSHA publishes their final rule, and that final rule has the current, what we're seeing in these proposed rules, the definitions for negligent, not negligent, reckless disregard, how does an inspector make a determination of whether or not something is an unwarrantable failure? MSHA's inspection manual points an inspector to the concepts of high negligence and reckless disregard when identifying what could possibly be aggravated conduct. But what happens if a citation is issued with negligent, right? The operator has been negligent, but how do you identify aggravated conduct within that category? So is MSHA on the proposed rule, are they saying, well, what the MSHA's inspectors are going to start doing then is start assessing or assigning reckless disregard in order to get to the unwarrantable failure? So I think that's another issue that we're going to want to be aware of and keep an eye on if this proposed rule advances to the final rule stage with those current proposed definitions intact. And like I just mentioned, the proposed rule will increase the statutory minimum penalties for unwarrantable failures by 50%, 104D1 would be $3,000, 104D2 would be $6,000. Now, I find it interesting there. This is an important concept to think about. Is MSHA's issuing a proposed rule, and so presumably if this proposed rule becomes final, right, it's published in the Federal Register, it's published in 30 CFR Part 1, it replaces 30 CFR Part 100, that is still a rule, right? It becomes a regulation at that point if it is published in 30 CFR, and it does not have the effect of changing or modifying the Mine Act in any way. And so when MSHA refers to statutory minimum penalties, currently the Mine Act, right, as amended by the Miner Act of 2006, right, the statutory minimums in that statute, the 104D1 citation and order, $2,000 minimum penalty, 104D2 orders, $4,000 minimum penalty. And so MSHA can say in their rule, hey, we want to modify these statutory minimums and assess them as such. But I think the key concept is that statute is controlling, right? So MSHA can call it a modification of the statutory minimum, but it's not a modification of the statutory minimum. So I think that's an important concept to think about in terms of evaluating this power struggle between the Mine Safety and Health Administration and the Federal Mine Safety and Health Review Commission. Now, essentially, right, MSHA, Mine Safety and Health Administration, is the enforcement agency. Federal Mine Safety and Health Review Commission is an independent adjudicatory agency, that was kind of a tough word, right, created by the Mine Act. So the Mine Act, again, is the statute, right, has created the Federal Mine Safety and Health Review Commission, just as the Mine Act created the Mine Safety and Health Administration and has given MSHA all of its enforcement powers. So think about this in effect for a second, just in terms of the proposed rule. In the proposed rule, MSHA is seeking to limit the discretion of the Federal Mine Safety and Health Review Commission to assess penalties. And, MSHA gives a couple of different reasons. Consistency in penalties. They say, the Federal Mine Safety and Health Review Commission can hinder the effective enforcement of the Act, contributes to the excessive number of contests. And again, when we're talking in terms of penalty assessments, right, MSHA is concerned that the Federal Mine Safety and Health Review Commission reduces penalties or doesn't follow MSHA's assessed penalties when either affirming a citation or order, reducing a citation or order, and then, I guess, vacating, that doesn't really come into play, right? But again, just basically, right, going back to the basics, currently, both MSHA and the Federal Mine Safety and Health Review Commission must follow the same 6 criteria to determine civil penalties. And Section 110I of the Mine Act, right, specifically grants the Federal Mine Safety and Health Review Commission the ability to assess penalties. MSHA uses either regular assessment or special assessment to assess penalties, right? We talked about that. Federal Mine Safety and Health Review Commission, so again, when we're talking about contesting a citation, contesting an order, and the judge hears that, Federal Mine Safety and Health Review Commission itself hears that, right? They review penalties, what's called de novo, right? So they do not follow the regular assessment formula, but instead evaluate these criteria, these 6 criteria, to determine the appropriate penalty. So what MSHA is essentially proposing to do through this rule, so again, they're not proposing, although I guess they could try, right? But essentially, for any real change to occur, there has to be a modification of the Mine Act limiting or changing the powers already granted to the Federal Mine Safety and Health Review Commission to assess penalties. And so what MSHA, the proposed rule, basically does is there's a couple of proposals in there, right? So MSHA's proposing to require the Commission to apply the penalty formula when assessing civil penalties, or MSHA saying, okay, the Federal Mine Safety and Health Review Commission and its judges, right, can raise or lower a penalty, but then they have to provide justifications for the change in penalty. But I just think it's interesting, right, where you have MSHA through notice and comment rulemaking trying to affect or suppress, if you will, the statutory powers given to the Federal Mine Safety and Health Review Commission. And frankly, I just can't imagine that that would be successful. But again, right, I think this is all geared towards limiting discretion, the discretion of these judges, right? And so it's sort of, it would almost be a chain reaction type effect, I think, where if you're starting with penalties, and then next thing you know, right, you're limiting these judges to the definitions of negligence in Part 100. And then you're limiting these judges to the Part 100 definitions for reasonably likely or occurred. You see what I'm saying? So this is just, I think, the beginning of a concerted effort really to suppress and change and limit the powers of the Federal Mine Safety and Health Review Commission as an independent agency. So we'll see how that works out. All right, and so quickly, I think we want to leave at least a few minutes for questions. MSHA states in their proposed rule, total penalties would remain generally the same. I think my response to that is not, right? I don't think that is an accurate statement. I think what we see in the proposed rule and the revised penalty chart, right, in Part 100, I think we see exponential increases. Well, I know, right, in the proposed rule, right, we see exponential increases in penalty amounts. And when I'm talking about exponential increases, I'm talking about starting at 50 points or more. For every point that you are, right, additionally assessed or assigned through the regular penalty assessment, there's a $500 increase in your penalty for just 1 point. At 55 points, for every point that there is an increase in your penalty total, right, corresponds to a $1,000 increase in total penalty. And at 61 points, starting at 61 points, you have a $5,000 increase per point. So I guess at least the good news, right, is the proposal retains the existing minimum $112 penalty and the maximum $70,000 penalty for non-flagrant violations. And we, Meredith Capuchin, one of our associates here, came up with these penalty workups. And what we do here is compare our current scheme to the proposed scheme. And so under the current rule, right, we have 208 possible points. So 208 being the maximum number of penalty points that any citation could be, or ordered, probably an order at that point, right, can be assessed or assigned, right? And then that that point total corresponds to a dollar amount. Under the proposed rule, that is reduced to 100 possible points. So in terms of, and to put this into context, right, when I say enforcement history is weighted more, your negligence is weighted more, right? So as a percentage of total points of this 100 possible points, right, you have more invested in either your negligence or repeat or your history points, right, than the other categories. Okay, so looking, and this is sort of, we came up with just the basic penalty assessment. So you can see under current scheme, right? So this is 50,000 annual hours worked at this particular mine. So right? No enforcement history points. Moderate negligence, and again, this is under current, right? Moderate negligence, 20 points. Reasonably likely, 30 points. Lost work days, restricted duty, 5 points. One person affected. So your total points is 60. Corresponds to the minimum penalty amount, $112. And so that same minimum penalty amount, right, from the old rule, or from, well, I call it the old rule, but our current rule, under the new rule, right, increases to $200. And again, that's just for a generic plain Jane citation. Now let's take a look at this one, where we do have some enforcement history added into the mix. And so with our annual hours worked, right, we've got 4 points. The enforcement history, so your violations per inspection day, repeat violations, adds up to the 16 points. And again, this is under the current scheme. Your negligence points are 20. Reasonably likely is 30 points. Lost work days, 5 points. One person affected. So your total points is 76, corresponds to $403 penalty. And again, looking at the proposed scheme, right? MSHA says, oh, yeah, these are going to be generally the same. I don't think that's factually correct. It's not supported by the evidence here, right? Because for this same operator, where yes, okay, we do have enforcement history, so we have the violations per inspection day, repeat violations per inspection day, that's 13 points. And remember, right, under this proposed scheme, that's weighted more heavily. Negligent, so it's just negligent, right, so not reckless disregard, not negligent, but negligent, that broad definition, 15 points. Reasonably likely is 14 points. Lost work days, restricted duty, 5 points. One person affected, 1 point. So your total points, 49. Corresponds to a $1,600 penalty. So that's a 4 times increase. Now I went ahead and took it one step further in terms of comparing or contrasting, if you will, reasonably likely to occurred, right? Remember when we were talking about the expansion, significant expansion of occurred. That's an additional 11 points for the occurred, right, category versus reasonably likely. If you add 11 points onto that 49-point total, again, this is under the proposed scheme, right, that gives us a 60-point total, and that corresponds to a $9,000 penalty. So yeah, I don't think penalties will be going down. So overall, right, I think this proposed rule obviously is a game changer, right? I think will change the definitions of negligence as we know them, change the definitions of unwarrantable failure as we know them, change the definitions of significant and substantial as we know them, and will probably trigger significant litigation to begin with. And depending on how that litigation goes, we'll see where we end up, frankly, right? If these expansive definitions of negligence is are upheld, reasonably likely is expanded, occurred is expanded, I mean, just imagine, right, if you can test one of these things, and what are you going to argue about negligence? That you weren't negligent, right? I mean, it's just hard to envision an administrative law judge that currently state mine operators are held to a high level of standard of care, right, when you're arguing no negligence, or we exercise due diligence. I mean, it's hard to imagine an administrative law judge, right, reducing something from negligent to not negligent. But I guess it's possible, right? I mean, if we're redefining all of these fundamental concepts of mine safety law, maybe that will usher in a different scheme, if you will, right, of a different concept of what constitutes reasonable care, right? You see what I'm saying? I mean, maybe there'll be different avenues available to us that we don't currently have. So I don't know. I'm definitely food for thought. You know, it's very interesting to kind of think about, you know, what MSHA is trying to do here. I think they're clearly trying to limit operators' abilities to achieve any reduction or change in a citation or order once written, even in a contest process. So I also encourage everybody, right, make your voice heard. The comment period has been extended to December 3rd, 2014. And it's not easy, right? I mean, I think in terms of how would I not only comment, but what would I propose to do differently? What changes, right, would I propose that would make this penalty assessment system more effective? And I think, you know, I don't know, right? I don't know the answer to that. I think in a perfect world, when I think in terms of mine safety and health enforcement, I'm thinking, well, ideally, right, if the Mine Act wasn't a strict liability statute, the operator had defenses available to them, you know, to avoid the overriding or issuance of citations and orders to begin with. I think that would be a significant first step. But I don't know that we'll ever see that happen, right? So in terms of, you know, realistic alternatives, you know, it's definitely something to think about. All right, well, we've got like a few minutes.
Thank you. Thank you, Chris. We will now begin our question and answer session. I see that we have several questions from the group, and we will try to get through a few of them before the time is up. If we do not address your question, Chris will follow up directly to those of you that have questions pending.
All right, well, we've got our first question here. It looks pretty good. It says, basically, do I think that MSHA will issue fewer citations and orders after this proposed penalty rule is published, if the proposed penalty rule is in fact published? And I think what they're asking about in terms of what sort of enforcement environment could we see, you know, I know that we saw a report from Joe Main, I think earlier in the year, saying that the overall numbers of citations and orders issued have been reduced. And I think that's a particularly good question to think about because, you know, certainly in response to the government attorneys or the government's position, right, that operators are contesting too much just because they want to, you know, achieve some sort of penalty reduction, right? I think our response to that is, well, just quit issuing bad paper. And so I think that's going to be the controlling factor, is whether or not MSHA continues to issue bad citations and orders. You know I was talking about this issue with the conference litigation the other day, and his thought was that this penalty rule would not change the contest rate. He's thinking, you know, that there's going to be significant issues out there, and you know, this isn't how to go about. This isn't the answer to reducing mine litigation. I've got another question here. Does the reduction correlate to mine closures? Wow, that's interesting. Maybe, right? I don't know. How do you go about answering that question? I mean, I think, I can't remember. I saw a report on that, and they were in terms of mines open now versus mines open back in, 2007, so before the penalties dramatically increased. And I think it was almost fairly steady. I think there were a lower number of smaller operators, but I think the larger operators have sort of absorbed the cost, if you will. And I think that's sort of the expectation going forward, right? These larger companies are going to bear the brunt of, these penalty rules. And again, right, I mean, I think the expectation is that these penalty amounts are going to be increasing. So, all right. Well, I think that's all the time we have for today.
Yes, thank you all for participating. We hope you will join us again in the future at one of our upcoming webinars. Our next two that may be of interest to those in this industry is one on EPA's Clean Power Plan, Understanding the Plan, the Opposition in Years Ahead. That will be on September 30th. And another one by our Health and Safety Practice Group here at Jackson Kelly on crisis management. That will be scheduled for November 12th. You may email marketing@jacksonkelly.com with any questions. And again, a copy of the presentation will be sent with a copy of the web link later today or tomorrow. Thank you. And to exit the webinar, simply click the exit button.